Ladies and gentlemen, the Fifth Circuit Court of Appeals just hammered another nail in the coffin for the ATF's pistol brace rule. Keep watching for the details. Hello everyone and welcome back to the channel. It's getting hard to keep track of all of the various Second Amendment lawsuits and their status these days. I feel like we all need a spreadsheet or something to know which case is in which court and has gotten what rulings and is in whatever state of appeals. If someone wants to get on that, it would be great. In the meantime, the ATF's pistol brace rule has just been kicked back down to the lower courts after the Fifth Circuit issued a preliminary injunction. This is now the second time the rule has been struck down, and I am sure the ATF is planning to try and take it all the way. But before we get into the details, I want to talk to you today about Attorneys for Freedom, a new self-defense plan for gun owners that was created by a criminal defense attorney. You might already have CCW insurance or have heard of these gun insurance plans. What you may not know is if the insurance company says the shooting was not justified as self-defense and you were convicted of a crime, coverage ends. You might not also be covered if you used your firearm in self-defense in a gun-free zone, had drugs or alcohol in your system, or if it was in a domestic dispute. Now, as a responsible gun owner myself, I would not want to trust my self-defense shooting to an insurance company. I'd much rather have the Attorneys for Freedom's experienced and aggressive legal defense team on retainer 24/7. So if you're a gun owner and want the legal defense without the endless exclusions of an insurance company, join the Attorneys on Retainer Self-Protection Program. Make the switch from your existing self-defense plan today and receive $50 off your sign-up fee using promo code LibertyDoll at my link down in the description. Now back to the news. Okay, so quick recap. In May, a 3-judge panel in Texas issued an emergency injunction against the ATF, stopping them from enforcing the new pistol brace rule. The court said that not only were the gun rights groups suing the government likely to win, but that the rule basically didn't do what the ATF said it would, was purposefully broad and vague, you don't say, and bore little resemblance to what they'd originally proposed. It's almost like they're a government alphabet agency. Celebration suggested that the injunction applied to everyone, but it turned out it only applied to members of those organizations. The injunction was also only temporary until an appeal could be heard in the courts. Then the full district court went the opposite direction, denied the injunction, and argued that the ATF were the likely winners. So the brace ban temporarily went back into effect for members of the Firearms Policy Coalition, Maxim Defense and their customers, and everyone else who had joined the lawsuit. So then FPC took the case up to the Fifth Circuit. A 3-judge panel heard the case and just issued their decision that, yes, the FPC and other organizations were likely to win the case if and when the full case is heard, and kicked it back down to district court to be reconsidered. Judge Reed O'Connor wrote, "The court finds that Mock, Lewis, and other individual FPC members are threatened with irreparable injuries in the absence of an injunction. The threats to individual FPC members are twofold. 1. Sustaining permanent and non-recoverable costs from their compliance with an unlawfully issued regulation, and 2. Suffering impairment of their fundamental right to keep and bear lawful arms in self-defense. The court finds that such threats of irreparable harm posed by enforcement of the final rule are credible, imminent, and intertwined with one another." He also noted what gun owners have been saying from day one, that the rule automatically turns law-abiding citizens into felons overnight, which seems to be the ATF's entire point. The ATF's own regulatory analysis concludes that the final rule has effectively reclassified 99% of all pistols with stabilizing braces to NFA rifles. Through seminal final rule adjudications, the ATF has already reclassified a whole host of specific weapons platforms and commercially available braced firearms to NFA rifles. Upon review of this record in conjunction with plaintiffs' declarations, there is no doubt that the final rule will subject both FPC members to criminal liability for currently possessing each of their braced pistols. The moment the Fifth Circuit's injunction dissolves, Mock and Lewis will become felons because their braced pistols have become unregistered SBRs under the final rule's reinterpretation of the NFA. Therefore, he wrote, the government would be barred once again from enforcing the rule against any of the plaintiffs in the case. Again, this only applies to the named plaintiffs and is only until the full case can be heard, but hey, 2 wins out of 3 isn't bad. As always, I will be watching this one, but everyone's watching this case at this point. Either way, please like, share, and subscribe. If you are new here, drop a comment down below for the algorithm. And as always, thanks for tuning in and happy shooting.